All right, well, good morning, everyone. It looks like we are now live streaming, so I think we are ready to start this mock trial. First of all, is there a representative from each team that's prepared to address preliminary matters?
Yes, Your Honor.
All right, and are you the prosecution or the defense?
Defense, Your Honor.
Okay, and you are Mr. Wilcox?
Correct.
All right, is there a representative from the prosecution who is prepared to address preliminary matters?
Yes, Your Honor.
And you are Ms. Harper, correct?
Yes.
All right, and you can both hear me okay?
Yep.
Yes, Your Honor.
All right, well, good morning. Let me start off by introducing myself. My name is David Taylor, and I'm a county judge up in Gilpin County, which is where Central City and Blackhawk are. I'll be the presiding judge for this trial this morning. We also have two scoring panelists. I will not be keeping score. The scoring panelists will, so I'll be here just to resolve any disputes that come up or objections, that sort of thing. But let me ask you a few preliminary questions. And Mr. Wilcox, I'll start with you because you're whose face I see on the screen right now. Do you have a roster that you can provide us?
Yes, Your Honor. Would you like me to put it in the chat?
Yeah, that would be ideal. Please do. All right, perfect. It's in the chat now. Can both the panelists see that?
And for the record, it is the second page of that PDF.
Okay. All right. Ms. Harper, do you have a roster that you can also provide us?
I do not believe I'm the one on my team with this roster, Your Honor.
Okay.
No, Your Honor, we just got news that we do not have a roster.
All right, and that's perfectly fine. What I'm going to ask both teams to do, and I think it'll be a workaround for this, is that when you each start your portion of the trial, so for both attorneys and witnesses, start off by giving us both your real name, and then if you're a witness, your character's name. That'll help us keep track of scoring and then who's actually on the screen. And then at the end of that section, I'll also ask both of you to give us your real names again, just so we can keep track of who is actually speaking. So those are the preliminary matters. As I think all of you are well aware, this is a new format for this. Obviously, we've had a little bit of difficulties this morning. We're supposed to start at 9 and it's 9:20. So bear with us on working through all of this. Thank you all in advance for doing that. Ms. Harper, being as I see your picture on the screen right now, are there any preliminary matters that the prosecution would like to address today?
Yes, Your Honor. I just want to confirm that our timekeeper will be keeping our time in the chat. And next, we would like time to be paused if there is any technical issues.
That'll be perfectly fine. If there are any technical issues, I'll make sure everybody gets treated fairly.
Thank you.
So are there any other opening matters or preliminary matters for the prosecution? Okay, it doesn't look like it. How about for the defense?
Yes, Your Honor.
Go ahead.
If at any time the court cannot hear a lawyer who is speaking, a witness who is testifying, or an exhibit being displayed, we ask the court to interrupt so the problem can be resolved.
I can certainly do that. Same goes for anybody else. If any of you can't hear me, speak up.
As well, Your Honor, under Competition Rule 7.4, may we screen share documents and exhibits before they have been admitted, with the understanding that the jury will constructively not see them until they've been admitted?
That's perfectly fine.
And lastly, Your Honor, under Competition Rule 7.4 and 4.7, a team may use Zoom annotation features to mark exhibits electronically. Once an exhibit is admitted, would the court like us to ask permission to mark the exhibit?
No, there's no need for that. So just go ahead and mark it however is appropriate.
All right, Your Honor. At this time, the defense is ready to proceed following introductions.
Okay, let me verify that we actually have our timekeepers. It's hard for me to see all of the participants in the list I've got here. I see that Audra Snyder is one of the timekeepers. Ms. Snyder, can you hear me?
Yes, Your Honor.
And are you ready?
Yes.
And I can hear you just fine. Do we have a second timekeeper?
Yes, Your Honor.
And what's your name?
Sienna Fisher.
All right, are you ready as well?
Yes.
All right, well, let's go ahead and move on to the trial itself. Let's start with the prosecution. Do you want to do your introductions at this point?
Yes, Your Honor.
All right, go ahead.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Eliza Harper. Today, I will be giving the opening statement, directing Kyle Cusack, and cross-examining Avery Becker.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Sierra Speth, and I'm going to be directing Alex Cifuentes and crossing Taylor Perkins.
Okay.
Good morning, Your Honor, member of the jury, opposing counsel. Today, I will be direct examining Detective Jordan Markowitz, cross-examining Professor Blake Van Owen, and be giving the closing statement.
All right, thank you. Would your witnesses like to introduce themselves at this point as well?
Good morning, Your Honor, members of the jury and the opposing counsel. I am Ben Kirchner, and today I will be portraying the role of Alex Fuentes.
Good morning, Your Honor, members of the jury, opposing counsel. I'm Libby Cruiser, and today I will be portraying the role of Jordan Markowitz.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Annalise Wampler, and today I will be portraying Kyle Cusack.
Okay, is that everyone for the prosecution?
Yes, Your Honor.
All right, thank you. Would the defense like to introduce themselves?
Good morning, Your Honor, members of the jury, opposing counsel. My name is Freya Naj, and I'll be delivering the opening statement for the defense. I will be conducting the direct examination of Blake Van Owen, and I will also be conducting the cross-examination of Kyle Cusack.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Daniel Nakayama, and today I'll be conducting the direct examination of Taylor Perkins, as well as the cross-examination of Jordan Markowitz.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Spencer Wilcox, and today I will be conducting the cross-examination of Alex Cifuentes, the direct examination of Avery Becker, as well as delivering the closing arguments on behalf of the defense. At this time, may our witnesses please introduce themselves?
Please.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Henry Falconetti, and today I am Professor Blake Van Owen.
Good morning, Your Honor, members of the jury. My name is Anna Sherman, and today I am Taylor Perkins.
Good morning, Your Honor, members of the jury. My name is Bella Burgess, and today I am Avery Becker.
All right, are there any other introductions for the defense?
Yes, one more.
Oh, okay.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Audra Snyder, and I am the timekeeper for the defense.
All right, and just to verify, you're ready to go?
Yes, Your Honor.
All right, and I know our other timekeeper is on here as well. I have lost track of, there she is, Ms. Fisher. Ms. Fisher, are you prepared as well?
Yes.
All right, is the prosecution ready to give an opening statement?
Yes, Your Honor.
All right, you can start when you're ready. And I'm going to put myself on mute. I'll be able to unmute myself when needed.
May it please the court, Your Honor, counsel. Reckless, revenge, responsible. Members of the jury, my name is Eliza Harper, and I'm here today with my co-counsel, Sierra Speth and Connor Badger. We represent the state of Colorado, and today we are here to present evidence against Avery Becker, a reckless teenager who sought revenge against her high school coach, Mackenzie Brackman, and was responsible for his murder. We, the people of the state of Colorado, have charged Avery Becker with murder in the first degree and second-degree burglary of a dwelling. Reckless. The evidence will establish that Avery Becker was a reckless teenager who didn't follow through with her commitments, who didn't care about other people, and was completely focused on herself. Avery Becker lived a carefree life with no consequences for her actions. Avery Becker was a student at Colorado High School and a member of the Colorado High School mock trial team. The victim, Mackenzie Brackman, was Avery Becker's mock trial coach. Today, you will hear testimonies from Avery's teammates, Alex Cifuentes and Taylor Perkins, about Avery Becker's troubled relationship with the victim, that Avery Becker and the victim did not get along and were constantly feuding. You will hear evidence that when Coach Brackman demoted Avery Becker to the B team, Avery Becker convinced her friend Taylor Perkins to quit so that the coach would be forced to put her back on the A team. You will hear that after a heated exchange that Avery Becker vandalized Coach Brackman's car, and after Coach Brackman kicked Avery Becker off the mock trial team. After, Avery Becker will admit to you that she said she would get back to Coach Brackman if it was the last thing she ever did. You will also hear from her friend and teammate, Alex Cifuentes, tell you about the text messages that he received from Avery Becker, telling him about her plans to break in and crash Coach Brackman's house. Revenge. You will then hear evidence about how Avery Becker carried out her revenge on Coach Brackman. On March 6th of 2020, Avery Becker went to Coach Brackman's house wearing a mask and unlawfully broke into his home with the intent to commit the crime of criminal mischief. Police Detective Jordan Markowitz and crime scene investigator Kyle Cusack will walk you through the crime scene and provide compelling evidence against Avery Becker that establishes during the burglary that Mackenzie Brackman was murdered by the defendant. Responsible. After you have heard all of the evidence presented, I am confident that you will return a verdict of guilty and hold Avery Becker responsible for the murder of the victim, Mackenzie Brackman. This reckless teen who got revenge needs to be held responsible for her crimes. Thank you.
Thank you, Ms. Harper. Is the defense prepared to give an opening statement?
Yes, Your Honor. Just a second as I adjust my camera.
Sure, that'll be just fine.
Your Honor, can you see and hear me?
I can. I think you're good. So go ahead when you're ready.
A rushed investigation. A rush to judgment. The prosecution just told you that Avery Becker was a reckless teen who sought revenge. But this is not true, as the defense will demonstrate that this case is the consequence of a rushed investigation and a rush to judgment. Avery Becker did not have a perfect relationship with her coach, and because of this, the police automatically assumed that she was the main suspect. Due to the police's rushed investigation and rush to judgment, the blame of this case got placed on Miss Becker, the defendant, after a flawed and rushed investigation. A rushed investigation, a rush to judgment. The prosecution has the burden of proof. They must prove to you that Avery Becker broke into her coach's house and killed her coach. They must prove to you each and every element of the second-degree burglary charge and the first-degree murder charge beyond a reasonable doubt. But this will not be possible, as the defense will demonstrate through numerous examples the prosecution has not met their burden of proof. A rushed investigation, a rush to judgment. Today, the defense does not have a burden of proof, but we will call 3 witnesses who will all show you that Avery Becker had an alibi, that there was a lack of physical evidence, and that there was an uninvestigated alternate suspect. Let's begin with the alibi. Miss Becker will tell you she had an alibi. In fact, Taylor Perkins, one of Miss Becker's classmates, will confirm this alibi by telling you that Miss Becker and Miss Perkins were at the mall looking for Miss Becker's phone. Professor Blake Van Owen, the defense's expert witness, will also tell you that the cell phone records used to place Miss Becker at the crime scene do not work because cell phone records cannot work as GPS due to their imprecise measurement and large signal diameter. The police also did not investigate any of the individual phones involved in this case, including Miss Perkins' phone and Mr. Cifuentes' phone, even though the prosecution will tell you all of these devices play an important role in today's case. Next, let's talk about the prosecution's lack of physical evidence. None of the defendant's DNA was found at the crime scene. In fact, one of the prosecution's own expert witnesses will support this fact. Next, the prosecution will also try to use security camera footage to place Miss Becker at the crime scene, but as seen in those videos, the only characteristic you will be able to see of the perpetrator is their height and their build. Finally, the police rushed their investigation and rushed to judgment before even investigating every possible suspect. Mr. Van Owen will show you an alternate suspect, Blair Rollins, who the police disregarded and who had a strong, potent, and personal motive. A rushed investigation. A rush to judgment. Today, the evidence will show you that the police rushed to judgment. The police rushed their investigation, and because of this, the prosecution will be unable to meet their burden of proof. Because of all these factors, at the end of today's trial, we will ask you for a verdict of not guilty. Thank you.
All right, thank you, counsel. Is the prosecution prepared to call the first witness?
Yes, Your Honor. We would like to call Alex Cifuentes to the stand.
All right, and like I said, what I would like you to start with is if I could have the lawyer's name first and then the witness's real name as well. And then you can go ahead and get started after that.
All right. I am Sierra Speth, and I'm going to be directing Ben Kirshner, who is playing Alex Cifuentes.
All right, perfect. And if you could try to remind us of that at the end of the testimony as well, that would be ideal, but you can go ahead. Thank you.
All right. Please state your name for the record.
Alex Cifuentes, Sifuentes.
Are you a student at Colorado High School?
Yes, I was a member of the mock trial team.
Do you know the defendant, Avery Becker?
Yeah, we were pretty good friends, and we were on the mock trial team.
And are you good friends with Avery Becker?
Yeah, I would consider us best friends.
And from your perspective, how good a relationship did she have with Mr. Brackman?
It wasn't very good. Brackman's always stressing the importance of preparation, yet Avery almost never delivered.
And how good of a relationship did Ms. Becker have with the rest of the mock trial team?
It also wasn't very good, basically for the same reasons of preparation.
Was Coach Brackman a good coach?
Yes, he was always trying to find some way to better the team.
Did you work hard on the mock trial team?
Of course, I would consistently revise my my examinations.
Did Avery work hard?
No, she always was lacking that that preparation to push yourself forward.
Did Avery like Coach Brackman?
No, I think
I'm sorry, can you repeat that? I couldn't hear what you said.
Objection lacks foundation.
Your Honor, may I respond?
I'm sorry, I think that there might have been some kind of connection problem, at least on my end. Everything went silent for a minute. There was a question, it got cut off. I'm not sure if there was an answer, and then the next thing I heard was the objection.
Would you like the question re-asked, Your Honor?
Yes, please, if you could re-ask the question.
Did Avery like Coach Brackman?
Objection lacks foundation.
Okay,
Your Honor,
if you go ahead and respond, I'm sorry.
It does not lack foundation because it is showing what Alex has seen, and it can help prove what has happened.
Mr. Wilk, yeah, go ahead.
Your Honor, this witness cannot testify to what was in the mind of Avery Becker, especially in regards to how she felt about other people.
Okay, I think he can give his opinion, so the objection's overruled. You can go ahead.
Was there a point when Avery's relationship with Coach Brackman reached a boiling point?
Yes, during the regional tournament, Avery came extremely unprepared, and Brackman was very disappointed in that.
And what happened after that?
After that, Avery had received her awards, and Brackman told her to not confuse good lawyering with good showmanship.
And was the team happy about that?
Well, they weren't happy about their awards. It was like a slap in the face that someone with a lack of preparation was getting all these rewards for the wrong reasons.
And how did Avery react?
Avery was also quite upset. She just felt like she deserved them, really.
And what did Avery do?
Avery ended up taking a marker on her way out from a meeting and wrote "Worst Attorney Award" on Brackman's Porsche.
Objection, improper character evidence, move to strike.
Is there any response?
No, Your Honor, I'll just move to the next question.
Okay, go ahead.
Was the team impacted with Avery getting kicked off?
Yes, we were in a very bad spot, and Brackman was trying to find some way to get a substitution, but it was difficult for him to do so.
And after Avery got kicked off the team, did she contact you?
She did. She asked me if I could ask Brackman to get her back on the team, but I only did it for the team, not for Alex. Or not for Avery, sorry.
And did Coach Brackman let her back on the team?
No.
How did Avery respond?
Avery ended up sending me text messages that were quite threatening to Brackman and his property.
Your Honor, at this time, may I show the witness what has been previously marked as exhibit number 14 for identification?
Go ahead.
Mr. Cifuentes, can you identify this document?
Yes, these are the screenshots that Avery had sent me, or these are text messages that Avery had sent me.
And are these text messages true and accurate from the ones that were sent to you by Avery Becker?
Yes.
May I publish this record to the jury?
Go ahead.
Were you contacted by the police during their investigation?
Your Honor, if I may, are these exhibits admitted?
Are you asking for admission of these exhibits?
Yes, Your Honor.
Is there any objection?
Yes, Your Honor, hearsay.
Any response?
Yes, Your Honor. Pursuant to Rule 801 D2, the opposing party's statement and Alex Cifuentes can be admitted to pursuant Rule 803(1) as an exception to the hearsay rule, which allows present tense impressions to be admitted when the statement describing or explaining an event or condition is made during the time the declarant perceived it.
Mr. Wilcox, do you have any further argument?
Yes, Your Honor. To the 801D2 objection, we contend that Avery Becker did not actually send these texts, so they don't fall under that exception.
Your Honor, may I respond?
Go ahead.
Through the statements, we do not have full proof that Miss Becker has not sent these messages. Therefore, we cannot really decide if it goes or if she has or hasn't said it.
I'll go ahead and admit this. You said it's Exhibit 14?
Yes.
Okay, Exhibit 14 is admitted. You can go ahead.
Hi, I think I cut out. Can you guys hear me?
I can hear you now. I think I was about to ask. So if
Oh,
you were asking the question, go ahead and start it over again.
Okay. What was the threat in this text messages by Avery Becker?
This threat was about when Brackman goes to work that Avery would break into their property and trash the place.
Were you contacted by the police during their investigation?
I was, yes. They asked for me to, I ended up bringing in the screenshots of these text messages.
Did you go to the police station for an interview?
I did.
And did you provide the phone to the detective later?
No, I did not. It was too old and not traded it in.
Did the defense investigator attempt to interview you before the trial?
Yes, they did, but I quickly stopped the investigation or stopped doing the investigation with her or interviews with her because I knew I was being investigated for faking text messages.
Are you aware that the defense has accused you of stealing Avery's phone?
I am.
Did you steal Avery's phone?
No, I did not.
No more questions, Your Honor.
Okay, is there any cross?
Yes, Your Honor.
Go ahead.
Mr. Cifuentes, first of all, I'd like to thank you for being here. And let's get right into it. You claim on direct that you were best friends with Avery Becker.
I do.
But really, you guys were actually rivals, weren't you?
It was kind of like a relationship where it was a competitive, friendly relationship.
So that's a yes?
Yes.
All right, let's dig more into that. You really only spent time with Avery at mock trial, correct?
Yeah.
And you said on direct that you always worked hard for mock trial.
It's true.
That you were always revising your content.
Yeah.
That you always came to practice prepared.
Yeah.
Did hours of rehearsal for it.
True.
But in contrast, you say that Avery was never prepared.
It's true. She was just very good at acting.
Exactly. She was constantly late as well.
Yes, it's just not how you should be presenting yourself.
Exactly. You did not like that, did you, Mr. Cifuentes?
No.
And you think that she could just make stuff up on the fly, right?
She could, yeah.
Without any hard work or preparation?
Yes.
And this irked you, didn't it?
Of course it would. I mean, it's like it's slap in the face when someone just does all this stuff and gets away with it.
Exactly. You thought it was a slap in the face, didn't you?
Yeah.
And you think that a lot of people on the team just couldn't stand her.
It's true. She just didn't deserve it.
You felt that she left the team in a constant state of anxiety.
Yeah.
And you didn't like how she treated her teammates.
I didn't.
In fact, you think she didn't even have any real talent.
Man, she was just very good at acting. She didn't have any good lawyering.
You thought that she was just coasting along on her good looks.
Yeah.
So because of all this, you confronted Coach Brackman about her, correct?
I did.
Multiple times, in fact.
That's true.
Because you thought that she was dragging the team down.
She just wasn't a good influence with her lack of preparation.
So that's a yes. You thought that she was dragging the team down?
Yes, more or less.
But when she was confronted, you hated how she always played the victim.
She did. She always thought she was right.
And then eventually she got kicked off the team, correct?
Correct, yeah.
And because of that, you got a larger role, didn't you?
Yeah, you could say that.
And because of this larger role, you are now in the position to get the Best Attorney Award that you mentioned on direct, correct?
Correct.
Okay, Mr. Cifuentes, let's move on to the investigation. You got a call from the police detective, correct?
Correct.
Asking you to go down to the station for an interview.
Correct.
And you told the detective about these supposed text messages from Avery you received.
I did.
But at the interview, you didn't even bother to bring your phone.
I left it in the charger.
Objection, Your Honor, asked and answered.
Mr. Wilcox, do you have any response?
Your Honor, this is a cross-examination question for clarity to the jury.
Okay, I think it's permissible. The objection's overruled. Go ahead.
So you forgot your phone.
I left in the charger, yes.
So instead, you sent the detective screenshots.
Correct.
And then you sold this phone months ago, didn't you?
I did. It was
You no
just
longer have it.
I do not.
So Detective Markowitz never got a chance to see the physical phone, correct?
Correct.
Nothing further, Your Honor.
Is there any redirect?
Yes or no, Your Honor?
All right, let me make sure I've got all of your names correct. Sierra Speth for the prosecution, Benjamin Kirshner as the witness, and Mr. Wilcox as as Spencer Wilcox as the defense attorney.
Yes, Your Honor.
All right, thank you all. Is the prosecution prepared to call the next witness?
Your Honor, I believe we are having some technical issues.
Okay, if the clocks are still running, let's go ahead and pause them and then just let me know when you're ready, okay?
Thank you, Your Honor. Your Honor, our next lawyer was kicked off the call, so we are just waiting for him to arrive back.
Okay, thank you.
Your Honor, our lawyer is in the waiting room.
All right, give me just a second. I haven't gotten a message. Hang on.
He's here now.
Sorry, Your Honor, I lost connection to the call, but I'm back.
No apologies necessary. Let me make sure we've got the defense ready. Is the defense prepared?
Yes, Your Honor.
Okay, and are our timekeepers still here?
Yes, Your Honor.
Okay. All right, let's go ahead and start with the next witness.
All right. Prosecution would like to call Detective Jordan Markowitz to the stand. Could you please state your name for the record and spell your last name?
Yes, my name is Jordan Markowitz. It's spelled Markowitz.
And how are you employed?
I've been with the Denver Police Department for 13 years, and I've been a homicide detective for 7 years now.
And do you have any specialized training that applies to this case?
Yes, I have a cell phone technology and forensic data recovery certificate from the American Academy of Law Enforcement.
And how did you receive that certification?
To get my certification, I had to complete a 3-day training course, and I as well completed a certification test.
And what are you able to do through forensic data recovery?
I'm able to download information from a cell phone, acquire and interpret cellular records and cell tower data, which allows me to determine where a cell phone was located at a given time and date.
At this time, I move to have Detective Jordan Markowitz admitted as an expert in homicide investigations and in cell phone technology and in forensic data recovery.
Is there any objection from the defense?
There's no objection, Your Honor.
Okay, thank you. She is so qualified. Go ahead.
All right. Were you assigned to investigate the death of Mackenzie Brackman?
Yes, I was assigned on March 6, 2020.
And did you know the victim?
I didn't realize that I did initially, but later I recognized him as a criminal defense attorney.
And what was the call that brought you into this case?
A passing motorist saw a potentially passed out person on the porch of Brackman's house, and when the paramedics found the victim, we got called in.
And what happened when the officers were called in?
Officers arrived and secured the scene, and I responded as soon as I could get there.
What did you notice upon arrival?
Upon arrival, I observed that the front door was open. The victim was face down on the floor just inside the residence in a pool of blood, and a large knife was visible on the floor just past the victim's body.
Your Honor, may I approach the witness with what was previously marked as Exhibits 1 and 6?
That'll be fine. I take it that means you're going to display it on the screen?
Yes.
Okay. Yeah, that's fine. Go ahead.
All right. Could you, Detective Markowitz, could you identify Exhibit 1?
Yes. Exhibit 1 is a photo of the victim passed out just inside the residence, and you can see the blood on the floor.
And could you identify Exhibit 6?
Yes, Exhibit 6 is a photo of the knife from the crime lab.
And are these photos a fair and accurate representation of what you observed at the crime scene?
Yes.
At this time, I move the admission of Exhibits 1 and 6 into evidence.
Is there any objection to Exhibits 1 and 6?
There's no objection, Your Honor.
Okay, they're admitted.
And may I have permission to publish these photographs to the jury?
That's fine.
All right. Detective Markowitz, is there anything you'd like to address regarding Exhibit 1?
Yes, you can see from Exhibit 1 that the victim was near the front door, and from the angle of the body, it appeared that the victim had most likely fallen to the ground while trying to leave the residence. You can also see in the photograph that the victim had a security camera.
And what about Exhibit 6?
Exhibit 6 is a photograph of the knife taken from the crime lab.
All right. Moving away from the evidence. What did you do after observing the Ring camera in the entryway?
Well, after seeing the Ring camera on the front porch, I decided to walk around the side of the house, and I noted 2 additional Ring cameras, one aimed at the gate in the backyard, which was unlatched, and one aimed toward the back door. When I got to the back of the home, I determined that the back door had been left opened.
And what did you do at that point?
I entered the house through the back door and observed that the residence was slightly in disarray and there was a partially open kitchen drawer containing several knives.
And did you notice anything else?
Yes, next to the kitchen was a dining area and one of the chairs was knocked over and there was a broken plate on the floor. From the table, I could see the open front door, including the knife on the floor, and there was cast off blood splatter on the wall and ceiling near the door.
Your Honor, may I approach the witness with what has previously been marked as Exhibit 7?
Go ahead.
All right. Did you identify this photograph?
Yes, Exhibit 7 is a photograph of the knife drawer.
And is this a fair and accurate representation of the knife drawer as you observed it?
Yes, it is.
And did you observe any? Oh wait, I move the admission of Exhibit 7 into evidence.
Is there any objection to Exhibit 7?
Yes, Your Honor, I object to relevance.
Is there any
Yeah.
response? Yeah, go ahead.
This is relevant to show that there are lots of types of knives and not just the knife and the knife block that could have been used at the crime scene.
Okay, I think that's relevant, so it's admitted. You can proceed.
All right, and may I have permission to publish Exhibit 7 to the jury?
Yes.
All right. Did you observe anything else around the house?
Yes, I did. I looked throughout the rest of the house and noted that there were no other victims and expensive items such as a laptop computer and multiple flat screen televisions had been left undisturbed.
And were you able to obtain any video from the Ring cameras?
Yes, I was able to access everything the various cameras captured on March 6, 2020, and there were 4 different videos.
All right, Your Honor, may I approach the witness with what has previously been marked as Exhibit 10?
That's fine. Go ahead.
All right. Detective Markowitz, do you identify this exhibit?
Yes, I recognize this link in this video as one of the videos from the Ring camera that I obtained during my investigation.
I move the admission of this video and for permission to publish the video to the jury.
Is there any objection?
No objection to the admission of this exhibit, Your Honor.
Okay, the video is admitted.
And what did you learn by watching the videos?
I learned that the intruder was wearing a hoodie and some type of mask and gloves. The intruder initially tried to open the front door, but it was locked. From there, the same person went around the side of the house and opened the gate, and then entered the residence through the unlocked back door. Finally, the video shows the same person running out the front door.
Moving on, what did you do next to investigate this case?
I turned to the evidence and I downloaded the contents of the victim's phone, and I found a tremendous number of text and email messages related to something called mock trial. I also realized that the victim was wearing a high school mock trial t-shirt. I was able to determine that he was a mock trial coach for Colorado High School.
And did you investigate his work as a mock trial coach?
Yes, while originally it seemed highly unlikely that his mock trial activity had anything to do with his death, I needed to follow up on all possible leads. I obtained a list of students on the team, and shockingly, the first student I reached out to gave me my biggest break in the case.
And who did you speak with?
I contacted Alex Fuentes, and he indicated that another mock trial student had texted something about a plan to trash the victim's house. After that, I had Alex and his parents come to
Objection. Hearsay.
Is there any response?
I would like to respond according to the rule that states that statements that go against the defendant's best interest can be used as evidence.
May I respond, Your Honor?
Go ahead.
I was under the impression that Detective Marcos is testifying on a conversation that took place between herself and Alex Cifuentes. So I don't believe those were statements of the defendant.
Oh, okay. Thought you were talking about the text messages. Okay, no response.
Okay, the objection's sustained. So move on, you can go ahead.
All right. And based on those text messages, who made the threat to trash the victim's house?
I learned that Avery Becker, a senior, had made the threat after she was kicked off the mock trial team for vandalizing Mr. Brackman's car.
And did you actually see the text messages that were sent by Avery Becker?
I did. Unfortunately, Alex had not brought his phone to the interview, but he sent me screenshots of the text messages the day after our interview.
Okay. And what did you do after that?
I immediately contacted Avery Becker in order to interview her, but my request was denied by her legal counsel. I also obtained a warrant to search Avery Becker's cell phone, but when I called her attorney, I was told that she claimed to have lost her phone on March 5th and was no longer in possession of it. I had to get a court order to obtain account records and cell tower.
Go ahead.
I was objecting to hearsay, Your Honor.
Okay, I thought I heard something. It was very muffled. So you said hearsay?
Yes, Your Honor.
Okay. Is there any response, Mr. Badger?
What were you objecting to?
Your Honor, may I respond?
Sure, go ahead.
Your Honor, I was objecting to Detective Markowitz's testimony about the conversation that took place between herself and Ms. Becker's attorney.
All right, Mr. Badger, any response to that?
Yes, since my client was there at the conversation, I do not believe that that is, in fact, hearsay.
Mr. Nakayama, any further argument?
No further argument, Your Honor.
Okay, I do think that qualifies as hearsay, so the objection is sustained and you can go ahead and continue.
All right, now moving on. Were you able to obtain the cell tower records?
Yes, although technically what I received are call detail records or CDRs. First, let me explain. Cell phones constantly reach out to find cell towers that they can communicate with, even when the phone isn't in use. Thus, if you can access all the cell towers in your area, you can accurately determine where somebody is, even if their phone is in their pocket.
Your Honor, may I approach the witness with what has previously been marked as Exhibit 16?
Go ahead.
All right. Detective Markowitz, could you identify this exhibit?
Yes, they are maps with the cell towers, as well as their ranges of use within the vicinity of Brackman and Becker's house. As well, it shows the route believed to be taken by Becker to Brackman's house on March 6th.
Is this image a fair and accurate representation of the cell towers?
Yes, it is.
I move the admission of Exhibit 16 into evidence.
Is there any objection to Exhibit 16?
Yes, Your Honor.
Go ahead. Oh, Mr. Nakayama, we might have lost you. It looks like you're frozen on the screen. So if the timekeepers can pause the clocks, we'll see what happens here. Mr. Nakayama, can you hear me?
I can. Can you hear me, Your Honor?
Yeah, you froze for a minute there. So let me get the timekeepers to restart. And why don't you repeat your objection?
I objected to hearsay, Your Honor.
Is there any response? You go ahead.
I believe that since these images were created by my client, I think that she should be able to introduce these into evidence.
Mr. Nakayama, any further argument?
Your Honor, I believe the writing in the on the map itself is an assertion of a fact, Your Honor.
All right, I don't think this qualifies as hearsay, so the exhibit can be admitted and you can proceed forward.
Okay. Do I have permission to publish Exhibit 16 to the jury?
Go ahead.
All right. What information and conclusion did you make after looking at the call detail record data?
After looking through and studying the CDR data, I concluded that Becker was home between 12:45 and 12:50 on March 6th, then left and drove towards Brackman's home, most likely driving along Rock Creek Parkway, as seen on the route at around 12:55, and then from 105 to 117 was at Brackman's house. Exhibit 16 shows what I believe is the route taken by Becker.
And based on your experience, what could you conclude from all of the evidence that you found?
It was obvious that the victim had caught someone breaking into the home and had likely confronted the intruder with a large knife from the kitchen, but the intruder must have gotten control of the knife and stabbed the victim.
No further questions, Your Honor.
Is there any cross?
Yes, Your Honor.
Go ahead.
First, may I ask for a brief time check? May I proceed, Your Honor?
You may. Did you see that message in the chat?
I did, Your Honor.
Okay, go ahead.
So, Detective, I first want to talk about the scene of the crime. You testified that photographs of the blood spatter were taken, right?
Yes.
But you lost these photographs, didn't you?
I didn't lose the photographs because I wasn't in control of taking the photos, but they were lost.
So, therefore, Detective, no one has any access to these photographs at this time, do they?
No.
And Detective, now I'd like to direct your attention to Alex Fuentes. You obtained a list of the mock trial students for Colorado High School, correct?
Yes.
And Alex Fuentes' name was the first name on that list, right?
Yes, it was.
And during your first interview with Mr. Cifuentes, he made you aware of a text conversation he received from who he claims was Avery Becker, right?
Yes.
But Detective, you asked Mr. Cifuentes to bring in his cell phone at this point, right?
Yes, although for the first interview, he forgot it, but it seems very normal. I mean, anyone that's being called into the police station for an interview, their first thought isn't to bring their cell phone.
I think, Detective, you're getting a little bit ahead of me. But that is a yes to my question that he did not bring his cell phone in?
Yes.
And Detective, this may have been one of the only times you've encountered a teenager who didn't have their cell phone on them, correct?
Yes, but again, like I said before, it seems normal for being called into the station for a police interview.
But Detective, that is a yes to my previous question.
Yes.
And Detective, you never reached out to Mr. Cifuentes to bring in the phone again at a later time, did you?
Correct, because he sent me screenshots.
Right, Detective, you decided to trust the screenshots, right?
Yes.
Detective, because you never physically possessed Mr. Cifuentes' cell phone, you were never able to download its contents, were you?
That's correct, but based off all the evidence that I was getting, it didn't seem necessary.
Detective, respectfully, I'm not asking about what you deemed was necessary. I'm simply just clarifying that you did not, or that you're not able to download the phone's contents, and that's true, right?
Yes.
And Detective, you also were not able to obtain the CDRs for that particular cell phone, were you?
Correct.
Now, Detective, you obtained CDRs for Avery Becker's cell phone on March 6th, correct?
Yes, I did.
And Detective, you did not obtain CDRs from Ms. Becker's phone for the time period in which Mr. Cifuentes claimed to have received text messages from the defendant, did you?
No, I didn't.
So thank you, Detective. Now, today, so you're an expert in cell phone tower analysis, right?
Yes.
You have experience in analyzing cell tower records, right?
Yes, I do.
So detective, you would agree with me in saying that a phone generally connects to the tower that gives it the best signal, right?
Yes.
And this oftentimes is the tower a phone is closest to, correct?
Yes.
But that isn't always the case, is it?
No, if that tower doesn't have the best connection or if it's being used by multiple other sources, then it connects to the next one closest nearby.
Right. But so that is yes, my question that a phone may connect to a farther away tower, right?
Yes.
And detective, you testified that Avery Becker's cell phone connected to the tower closest to Mackenzie Brackman's house, right?
Yes, it did.
And you determined from this that the cell phone was at Mackenzie Brackman's house.
I mean, there's always the possibility for the fact that it was connected to the tower that overlooked Sprackman's house. Yes.
But as you just testified earlier, that cell phone may have been at a more distant location, but still connected to the tower close to Mackenzie Brackman's house, correct?
Yes, but that is unlikely.
But detective, that still is a means of communication or a means of connection, right?
Yes.
Now, detective, I would now like to direct your attention to the Ring videos. You examined the Ring doorbell videos, right?
Yes, I did.
These videos contain the perpetrator, correct?
Yes, it did.
However, the perpetrator in those videos is masked, aren't they?
Yes, they are.
Therefore, you cannot identify the race of this person,
That is correct.
the gender of that person,
Correct.
or even a hair color.
Correct.
All you have is a generic size and build, correct?
Yes.
Thank you. No further questions.
Is there any redirect?
Yes, I'd like to conduct a short redirect.
Go ahead.
So Detective Markowitz, you said that even though those photos were lost, you were able to examine the photos and see them in person, correct?
Yes, I saw it on the day of the crime at the crime scene.
All right. And I lost my train of thought. You also said that you think that Avery Becker's phone connected to the closest tower because that's the best signal, right?
Yes, that's what most likely happened. It only connects to a different tower if that tower is being used by many, many people.
And no further questions.
All right, let me just confirm everyone's name. It was Connor Badger as attorney for the prosecution, Libby Cruiser as witness, and Daniel Nakayama as attorney for the defense.
Yes, Your Honor.
All right. The prosecution can call the next witness.
Your Honor, we would like to call Kyle Cusack to the stand.
Okay, let me make sure we've got the defense ready.
Your Honor, the defense is ready.
All right, thank you. You can go ahead and start.
Please state your first and last name for the record.
Kyle Kuzak, K-U-Z-A-K.
And Ms. Cusack, how are you employed?
I'm a certified crime scene reconstruction investigator with the Denver Police Department.
How long have you been a certified crime scene reconstruction investigator?
19 years.
What types of crimes do you investigate?
I investigate complex crime scenes, including home invasions, burglaries, and domestic violence and stuff like that.
At this time, Your Honor, I move for the admission of Kyle Cusack as an expert in the area of crime scene reconstruction pursuant to Rule 702.
Is there any objection to that qualification?
No objection, Your Honor.
Okay, the witness is so qualified, you can continue.
Ms. Cusack, did you investigate the scene of the homicide at 444 South Flower Street?
Yes, I did, as Varel has reviewed all police reports, ring videos, and photographs.
How do you approach your investigations?
2 key principles guide my work. First, I assume that every case is going to trial, So I conduct a thorough and comprehensive investigation. Then I create a witness tracking spreadsheet with key points of witnesses and subjects.
What did you do first in this case?
I used a witness tracking spreadsheet to summarize key points for witnesses and subjects.
At this time, Your Honor, may I approach the witness with what's been previously marked as Exhibit 17 for identification?
You may.
Can you see my screen?
Yeah.
Ms. Cusack, can you identify Exhibit 17?
Yes, Exhibit 17 is my work. It is the witness tracking spreadsheet, physical evidence tracking spreadsheet, flowchart, and timeline.
Is this a record that you created at the time you were reviewing the evidence?
Yes, it is.
Is this a record that you keep in a regular course of your business?
Yes.
Do you always create one of these records during your investigations?
Yes, I do.
At this time, Your Honor, I move for the admission of Exhibit 17 pursuant to the exception to the rule against hearsay, Rule 803, as a record of regularly conducted activity.
Is there any objection to the admission of this exhibit?
No objection, Your Honor.
Okay, the exhibit is admitted. Go ahead.
And permission to publish Exhibit 17 to the jury.
You may.
What conclusions did you reach as a result of your investigations?
I reached the conclusion that on the afternoon of March 6, 2020, the perpetrator matching the general height and build of the defendant, Avery Becker, approached the victim's residence and tried to open the front door, as captured by a Ring door camera. At that point, finding the front door locked, Avery Becker then went around towards the back.
Do you think the victim was alerted to the intruder?
Yes, I do, because the Ring app gives you notifications when it senses movement, and also a doorknob makes a sound when you try to turn it. Seeing that he was alone with an intruder, the victim grabbed a large chef's knife from the knife block on the counter.
What happened next?
Based on my analysis, the defendant and the victim proceeded to struggle near the back door, moving towards the kitchen. The victim, this is evidenced by scuff marks, a knocked over plate, or a knocked over chair, and a broken plate. The defendant then gained the knife and stabbed the victim one time in the back.
What happened after the victim was stabbed, Ms. Kuzak?
After the victim was stabbed, he made his way towards the front door where he then removed the knife. Sadly, the knife had nicked the victim's aorta and he bled to death shortly afterwards. The knife was found a few feet inside the front door.
Did your investigation lead you to any other conclusions?
Yes, this was clearly a planned burglary gone bad. The intruder knew the victim's patterns and habits and chose a time of day to enter the victim's home when he thought the victim would not be there. Yet the victim was there and he was killed with the same knife that he introduced to the encounter.
Thank you, Ms. Kuzak. No further questions, Your Honor.
Is there any cross?
Yes, Your Honor. Your Honor, can you see and hear me?
Yes, go ahead.
Okay. Good morning, Ms. Kuzak. Let's start by talking about the evidence found at the crime scene. The police found a bloody knife at the crime scene, correct?
Yes.
And isn't it correct that none of the defendant's DNA was found on this knife?
That is true, but the defendant was wearing gloves that was seen in the Ring videos.
And next, Ms. Kuzak, I'd like to talk about your investigation. Is it correct that your conclusion about this case is that it was a planned burglary gone bad?
Yes.
Your Honor, permission to screen share Exhibit 6.
Go ahead.
Co-counsel, could you please screen share Exhibit 6? please. I'm having technical difficulties.
Okay, let's pause the clocks.
I could pull up Exhibit 6 on my computer if you'd like me to.
If you're willing to do that, that might be the best way to proceed.
Yes, thank you very much. I'm sorry to inconvenience you, Ms. Kuzak, but could you please screen share?
Yeah. Is that good?
Yes, Ms. Kuzak, this is Exhibit 6.
All right, let's make sure we've got the clocks restarted first. Are the timekeepers ready?
Yes, Your Honor.
Oh, okay, thank you. Go ahead.
Ms. Kuzak, this is Exhibit 6. Isn't it correct that you believe that Exhibit 6 was used as the murder weapon in this case?
Yes, it is. Yes, I do.
And isn't it correct that you also believe that the brand of this knife is a Chicago cutlery knife?
Yes, it is.
And are you—
Objection, Your Honor. I don't see the relevance of the type of knife needed to be in this cross-examining.
Is there any response?
Your Honor, this is cross-examination. I'm allowed to ask. This is my time to ask questions, and the brand of knife goes to Ms. Kuzak's theory.
I think it's a fair question. You can proceed. The objection's overruled.
Thank you, Your Honor. May I proceed?
Yes, go ahead.
I'll ask the question again. Ms. Kuzak, is it correct that the brand of this knife is a Chicago cutlery knife, correct?
Yes, it is.
You may stop sharing, Ms. Kuzak.
Can you repeat that?
You can stop screen sharing, Ms. Kuzak.
Okay.
Aren't you aware that there is a knife block in Mr. Brackman's kitchen?
Yes, I am. I believe that that knife came from the knife block.
Aren't you also aware that the rest of the knives in the knife block are from a J.A. Henkel's knife set?
Yes, but it can be easily explained that the knife in the knife block could have been just replaced because those knives can grow old or dull. And the victim most likely.
You're getting ahead of me. I was just asking. That is a yes to my question. The rest of the knives in the knife block are from a J.A. Henkel's knife set.
Yes.
Objection, that question was already asked and answered.
Is there any response?
Your Honor, I was just clarifying the answer.
I think that's acceptable, so you can proceed forward. The objection's overruled.
So, Ms. Kuzak, you are also aware that J.A. Henkel's knives are more expensive than Chicago cutlery knives, correct?
I believe so.
So, Ms. Kuzak, would you agree that it is possible that the intruder or perpetrator could have brought the knife with them?
It is possible, but that is highly unlikely.
But again, Ms. Kuzak, it is yes to my question. It is possible.
Yes, but it's highly unlikely.
Let's move on. Isn't it correct that you observed some scuff marks in Mr. Brackman's kitchen?
Yes, I did.
And isn't it true that you believe that these scuff marks indicated a struggle?
Yes.
But isn't it also true that you can't tell me when those scuff marks happened?
That is true, but Seeing the broken plate and the knocked over chair, it definitely looks like there was a struggle.
So that is a yes to my question. You can't tell me when those scuff marks exactly occurred.
No, I can't.
Thank you. No further questions.
Is there any redirect?
Yes, Your Honor.
Go ahead.
Ms. Kuzak, would you assume that after a murder has happened, that the house where the murder occurred would look a little bit, would you say, messy?
Yes. And
So-
that Brackman's house did look a little bit messy.
So the broken plate and the scuff marks on the floor were most likely from the incident that occurred.
Yes, they were.
Thank you. No further questions, Your Honor.
Thank you.
Okay, let me just confirm everybody's name. I've got Eliza Harper as attorney for the prosecution,
Yes, Your Honor.
Emily Swampler as witness for the defense. I see you nodding your head. And Fry, is it Naji or Naj that you said your last name was?
Freya Naj.
Okay, thanks. I wanted to make sure I pronounced it correctly. So thank you all. I believe this is all of the prosecution's witnesses.
Yes, Your Honor.
All right, is the defense prepared to present its first witness?
Yes, Your Honor. We call Professor Blake Van Owen to the stand.
Right, and Mr. Badger, I take it you'll be the attorney for the prosecution?
I am.
Okay.
Your Honor, are you ready and is the timekeepers ready to proceed?
I am. I just want to make sure. Do we have our witness?
Yes.
Yes, sir.
Oh, okay. I'm sorry. I was waiting. So yeah, you can go ahead when you're ready.
Okay. Could you introduce yourself?
My name is Blake Van Owen.
And what is your current occupation, Mr. Van Owen?
I am a private investigator and a professor at CU Denver.
Before that, did you have any other jobs?
Yeah, I served as a police officer in the Aurora Police Department for a little while.
Have you attended college?
Oh yeah, I went to Ashford University, and there I got my master's degree in criminal justice.
Let's move on. What is your role in this case, Mr. Van Owen?
Well, you should know I was hired by the defense to review this police investigation.
And have you ever testified in court before?
Oh yeah, I know my way around a courtroom.
And specifically, in what areas have you testified?
I guess some big ones would be cell tower analysis, crime scene reconstruction, and forensic evidence techniques.
You just mentioned that you've testified as an expert in cell tower analysis. How many times have you testified as an expert in this area?
5 times, I believe.
Did your expert testimony include examining cell tower documents and records?
Well, yeah, there's not much to talk about otherwise, is there?
And you also mentioned that you've testified as an expert in crime scene reconstruction. How many times have you testified as an expert in this field?
8 times, I believe.
Your Honor, I would now like to tender Blake Van Owen, an expert in crime scene reconstruction, cell tower analysis, and general police investigation.
Is there any objection?
Yes, Your Honor. I'd like to conduct a brief voir dire of Blake Van Owen.
You may. Go ahead.
All right. You are currently a professor at CU Denver, correct?
That's what I said, yeah.
And you are currently not a police investigator?
Well, not right now. I was at one point.
And you've only testified in cell tower analysis on 5 occasions?
Yeah, well, that's enough to know about it.
And you've only testified as an expert in crime scene investigation 8 times?
Again, that's more than enough, I think.
And in all of your work as an expert, you've only testified as a defense witness, correct?
Yes, that's true.
And you left the Aurora Police Department under a shadow, correct?
Well, I'm not sure what you mean by that, counsel.
You left the Aurora Police Department because of a wrongdoing, correct?
I suppose you could say that, yeah.
And that was that you injured a woman of color during an arrest.
Your Honor, objection,
Go ahead.
relevance.
Any response?
Yes, this is showing that he might be opposed to police work, so he might want to testify against the police.
Ms. Naj, any further argument?
Yes, Your Honor, I don't see how this incident has anything to do with, has any relevance with the tendering of Blake Van Owen.
I think it's acceptable. So, Mr. Badger, you can proceed.
Okay. And you never fully cleared or forgave yourself for your conduct that evening, correct?
No, I haven't. That's one of my biggest regrets, I'd say.
And isn't it true that you were sued individually for that incident as well as the police department was sued?
That's true.
Your Honor, the prosecution objects to the admission of Professor Blake Van Owen as an expert, given the limited number of cases he has testified to previously, and given that he left the Aurora Police Department disgraced after he assaulted a young woman and caused the department and himself to be sued.
Ms. Naj, do you have any response?
As to the experience, I will cite Rule 702. Rule 702 says that an expert must, as a witness to be certified as an expert, they must either have training, education, or experience. And Professor Blake Van Owen has demonstrated that he does have experience in all three of these areas. I asked him questions earlier that he has testified as an expert in these areas several times, crime scene reconstruction 20 times, cell tower analysis 5 times, and as part of his expert testimony, he has reviewed documents in all of these areas. Therefore, he has plenty of experience in these areas. And since Rule 702 only asks for one of the following qualifications, training, education, or experience, he does have plenty of experience to be qualified and expert in these areas.
I think the objections raised go to weight rather than qualifications. So the witness is qualified as the requested expert, and you can proceed forward.
Thank you, Your Honor. Mr. Van Owen, what materials did you review in today's case?
I reviewed the police reports, the crime scene reconstruction by Kyle Kuzak, as well as the cell tower documents prepared by Detective Markowitz.
And during your reviewing, did you reach any conclusions?
Yes, I concluded that the police department has rushed to judgment and rushed this investigation, totally helter-skelter.
And could you explain a little bit more?
I'd say there are 3 big areas of the investigation that I'm particularly concerned with. The cell tower records, the investigation itself, and lack of investigation into an alternate suspect.
Well, let's begin by talking about the cell phone records. What conclusions did you reach about this particular topic?
Well, with the cell phone records, there's simply no way to prove Avery Becker's location just based off of cell tower data.
How did you reach this particular conclusion?
I looked through the phone records of Avery Becker and used my academic intuition.
How did you use the cell phone records?
When you look through the cell tower records, you can actually determine that the defendant could have been in a maximum of 6 miles from the victim's house. You can also determine that, the defendant's phone being at a location doesn't mean the defendant was at a location. Despite what you might believe about teenagers, they're not quite always glued to their phones.
More specifically, why are these cell phone records not enough to justify Avery Becker's location?
Well, cell tower data can't be used as a GPS because a cell phone doesn't necessarily connect to the nearest tower, rather just the one with the strongest signal.
let's move on to your next area of concern, the crime scene reconstruction. Did you reach any conclusions?
Yes, like I said, this investigation was extremely rushed. Evidence of varying levels of cruciality was simply omitted, and Detective Markowitz came to the easy conclusion, but not the correct one, I believe.
Why do you think the police's investigation was rushed?
I'd say there are kind of two big reasons for this.
What is the first reason?
First of all, several photos of blood spatters around the house were lost and corrupted in this investigation, which demonstrates quite a lack of competence on the police's behalf. I mean, I've taken a lot of photos of blood spatters. I've got an entire hard drive filled just with blood spatters. I have never lost one.
What is the second reason why you believe the police's investigation was rushed?
The police also failed to obtain Alex Cifuentes' cell phone.
Why didn't the police obtain Alex Cifuentes' phone?
I don't know. They simply accepted some easily manipulated screenshots from Cifuentes themselves with no follow-up.
And do the police have any kind of regulations or procedures around this area?
They do. The police department has specific cell phone processing technology just for situations like this.
Finally, Mr. Van Owen, let's talk about your third area of concern, the investigation into other suspects. Did you reach any conclusions about this topic?
Yes, like I said earlier, the police investigation failed to investigate a crucial alternate suspect.
Did you find this other suspect?
Yes, I believe the suspect to be former CHS student Blair Rollins.
What were you able to find out about Blair Rollins?
I looked through some CHS yearbooks, and I found out that Blair Rollins about matches the height and build of the intruder in the Ring Doorbell videos. And through some internet research, I also found out that he's probably not in Colorado anymore.
Did you find anything else through your research?
Yes. Blair's father, Jonathan Rollins, was actually convicted with Mackenzie Brackman as his defense lawyer. And in that trial, he said something along the lines of like, he'll get Brackman back if it's the last thing he does.
Oh, would you recognize this audio clip if it was played today?
Oh yeah, it was memorable.
I'd like to enter Exhibit 22 into evidence.
What is Exhibit 22?
May I lay some more foundation, Your Honor?
Go ahead.
Mr. Van Owen, are you aware of Exhibit 22?
Yes, I am.
And what is it?
It's an audio clip of Jonathan Rollins yelling some kind of threat to Mackenzie Brackman.
Your Honor, I'd like to enter Exhibit 22 into evidence. And it has been stipulated by the parties that this audio clip is authentic.
Okay. Mr. Badger, do you have any objection?
No objection.
Okay, Exhibit 22 is admitted.
Your Honor, permission to play Exhibit 22?
You may, go ahead.
Full counsel, can you please play Exhibit 22? Co-counsel, I wasn't able to hear the audio clip. Could you please play it again?
Yes, I'm really sorry. My computer is having trouble. Just give me 1 second, okay?
If needed, Your Honor, I can screen share it.
Okay, you know, that might be the easier way to do that. So go ahead.
Co-counsel, could you please play Exhibit 22?
I'll get you back, Brackman, if it's the last thing I do.
Thank you, co-counsel. You may stop screen sharing. Mr. Van Owen, did you know if Blair Rollins was present at his father's trial?
I do. Blair Rollins was present at that trial. It's kind of his Batman story.
And was Blair at school the day of the murder?
No, Blair Rollins was not at school the day of Mackenzie Brackman's murder.
Thank you. No further questions.
Mr. Badger, do you have any cross-exam?
I do. All right. Professor Blake Van Owen, your purpose here today is to attack the work of the investigators of this case, correct?
Well, I wouldn't say attack, but rather review the investigation.
Okay. Yet you yourself were not a perfect police investigator.
I'm not sure what you mean by that, counsel. I think I was pretty good.
Okay, well, I guess the mistakes you made caused you to leave the Aurora Police Department, correct?
Sure, yes.
And you now prefer to be called professor as opposed to detective or investigator?
I'm sorry, counsel. I don't understand the question.
Is it true that you prefer to be called professor instead of detective or investigator?
Oh, yes. I am very proud of my professor title.
And you only conducted a partial investigation of this case, correct?
That is true.
And you never even stepped foot inside the crime scene, is that right?
I didn't need to.
Okay, moving on. One thing that you agree with the prosecution about is that the evidence points to an intruder who broke into the home of the victim. And yet you
that's obvious.
Yeah, and you don't agree with the prosecution's depiction of the events inside the house, correct?
I do not.
And you don't believe that the victim and perpetrator got into a brawl or a scuffle?
No, the evidence indicates to me that the victim was simply attacked from behind.
And this is based on your claim that the only apparent investigation is the scuffing on the floor?
Yes, that's very thin evidence in my opinion.
But you reviewed all the evidence in this case, isn't that right?
I did.
And did you not note that there was an overturned chair?
I took that into account, and I still stand by my theory.
You still stand by your theory, even though there was also a broken plate on the floor.
Again, I don't think that that's particularly relevant evidence.
Well, isn't it possible that in the fight, they could have gone into the dining room and maybe knocked over a chair or broken the plate?
It's possible, sure, but the evidence indicates to me that that's not likely.
Okay. And you also believe that the perpetrator brought this weapon since the knife was a different brand than the knives in the block?
I do.
And didn't you realize in the photograph of the knife drawer that there are a lot of different brands of knives?
I took that into account as well, and I still stand by my theory.
And you believe that the perpetrator snuck up on the victim and stabbed him in the back while they were supposedly seated?
That's what I believe, yes.
And you do not think that the victim was alerted to the intruder because you don't know if the victim had their notifications on the Ring app?
No, the evidence seems to indicate that this was a surprise attack.
In Exhibit 10, we can see and hear the intruder wiggling the doorknob loudly. And even if the victim didn't have his Ring notifications on, don't you think that he would have heard the doorknob being wiggled?
I mean, I don't know. I'm not Mackenzie Brackman. He could have been hard of hearing.
Okay. And if Mackenzie Brackman was seated when he was stabbed, don't you think that there would have been blood stains on the couch or chair?
Well, the evidence doesn't seem to indicate that to me. Blood can actually be restrained quite a bit if the knife is left in.
Okay. And if the knife drawer was not where the knife was gotten in this case, why do you think that the knife drawer was open?
Mackenzie Brackman could have been cooking. There are a multitude of reasons for this.
All right, let's talk about the cell phone evidence. You acknowledge that the cell phone records show that Avery Becker's phone was near Mackenzie Brackman's house at the time of the murder.
Yes, Avery Becker's phone was near Mackenzie Brackman's house.
And didn't you think that Detective Markowitz should have obtained cell phone data for the day before the murder?
I do agree with that.
And you also thought that Detective Markowitz should have gotten cell phone data for Taylor Perkins's phone?
Yes, the police have technology just for that purpose.
But isn't it possible that you can also get those phone records?
I will admit that that is something that I omitted from my investigation as well, but I would like to point out that I am not the police, and it's their responsibility to get that evidence first.
Okay. And you also did not bother to investigate the mall or restaurant to see if your client was actually there at the times they said they were?
I didn't think that was relevant.
And did you bring any evidence into this case that proved that Blair Rollins could have committed this murder?
Yes, I have. We've talked about the audio clip. I've discussed Blair Rollins' height and build, the fact that he's not in Colorado anymore. I mean, there's a lot of evidence to demonstrate that Blair Rollins is the prime suspect in this case.
Okay. And you refer to yourself as a check on the police, correct?
If I don't do it, nobody else will.
And you are charging $450 an hour for your courtroom testimony?
Well, I can't do this for free. I have a divorce payment to pay for.
Though this is not your only job, correct? You're a professor at CU Denver.
Yes, I am.
Your Honor, objection, relevance.
Mr. Badger, any response?
This goes to show that he's being paid just under $7,000 at this point. And isn't that a lot of money, so that he might be a little biased against in this case?
Any further argument?
Your Honor, I object that I don't understand why the pay is relevant to this case, and I also don't think the Mr. Van Owen's job as a professor is relevant.
I think the source of pay and general work background are both relevant. So the objection's overruled. You can proceed forward.
Okay. And after the trial, you are also going to earn $1,000, correct?
Again, I have a divorce settlement to pay for. Can't do this for free.
No further questions.
Is there any redirect?
Yes, Your Honor, a brief redirect.
All right, go ahead.
Mr. Van Owen, what materials did you review in today's case?
Well, like I said earlier, I reviewed the police investigation, Kyle Kuzak's crime scene reconstruction, as well as Detective Markowitz's cell phone documents.
And why did you feel you didn't need to visit the crime scene?
I just thought that I had all the relevant evidence.
And to your conclusions, how did you reach your conclusions? Why do you believe your conclusions are correct?
Well, my conclusions, I just reached through some basic logic. And I think that the evidence points very strongly in favor of my conclusions.
And finally, why did you leave the police department?
I just didn't feel comfortable working with that institution anymore. I don't think that they really act in the interest of justice all the time.
Thank you. No further questions.
Your Honor, you're muted.
I knew it was going to happen at some point. Thank you. Let me just verify everybody's name. We've got Freya Naj for the prosecution, Mr. Badger for the defense, and Mr. Falconetti as the witness.
Other way around, Your Honor.
Oh, well, I apologize. But, I got your names right?
Yes.
Okay. All right. Are you prepared to call your next witness?
Yes, Your Honor. At this time, the defense calls Taylor Perkins to the stand.
All right. Is the prosecution prepared as well?
Yes, Your Honor.
And do we have our witness?
Yes, Your Honor.
All right. You can start when you're ready.
First, may I ask for a brief time check for time remaining on direct examination? Okay. May I proceed, Your Honor?
You may. You saw the chats?
Yes, Your Honor.
Okay, go ahead.
Good morning. Could you please introduce yourself to the jury?
Hi, my name is Taylor Perkins.
Ms. Perkins, do you go to school?
Yes, I do. I'm currently a freshman at CU Boulder.
Now, Ms. Perkins, do you know Avery Becker?
Yes, of course. We were teammates in our school's mock trial team.
Were you and Avery friends?
Friends? We were besties. I mean, we literally finish each other's sentences. We are that close. So yeah, we're definitely friends.
Now, Ms. Perkins, you mentioned that you and Ms. Becker competed on your high school's mock trial team. Do you know Mackenzie Brackman?
Of course I do. He was our coach.
Ms. Perkins, are you aware of why you are here in trial today?
Yes, I am.
Why is that, Ms. Perkins?
Unfortunately, Coach Brackman was murdered.
Ms. Perkins, did Avery Becker kill Mackenzie Brackman?
I know for a fact that Avery did not kill Coach Brackman.
How do you know this, Ms. Perkins?
Well, I was with Avery the whole day of March 6th. So seeing as we were nowhere near Coach Brackman's house, I don't see how it's possible. I mean, you can be in two places at once.
Thank you, Ms. Perkins. Now, I'd like to talk more about your time and Avery's time in mock trial. Could you elaborate on your personal experience in the program?
Well, I didn't have a huge liking for mock trial. It was a nice way to spend time with Avery and all, but overall it just wasn't to my liking.
And from your perception, how was Avery Becker at mock trial?
Oh, Avery was great. She was so talented. She could literally do the bare minimum. And, somehow she still came out on top. It did drive our coach nuts though.
Ms. Perkins, were you able to observe the interactions between Avery Becker and your coach, Mackenzie Brackman?
I'd say so, yeah.
Please elaborate on those interactions.
Well, you see, Avery was so talented at mock trial that she didn't really like to prepare much. Our coach, on the other hand, was a perfectionist. He liked when people came prepared to practice. So sometimes they didn't see eye to eye.
Did you observe any conflicts between the two?
Well, there is this one conflict that stands out to me the most. I believe it was before regionals. Avery came to practice completely unprepared. I mean, it was the worst I've ever seen her. And, as you can imagine, the coach wasn't exactly thrilled about it. And one thing led to another, and Avery got demoted to the B team.
Ms. Perkins, was this demotion permanent?
No, it wasn't. So I decided to step down. It was the right thing to do, and mock trial it wasn't the same without Avery.
Thank you, Ms. Perkins. I would now like to direct your attention to March 5th of 2020. What can you tell me about March 5th?
So Avery came over to my house and, we just hung out, played video games, the usual. And then I believe we got hungry, so we decided to go get something to eat.
Ms. Perkins, where did you guys go?
So we went to the Fry Shack, which is like a spot we go to hang out and have fun.
Ms. Perkins, is the Fry Shack a public place?
I believe it is, yeah,
Were there other patrons there?
definitely.
Who was there?
So our mock trial team was there, unfortunately.
And Ms. Perkins, what was so unfortunate about this interaction with your former teammates?
Well, we obviously came up to them and talked to them for a while. It was the polite thing to do. And then Avery got upset over something and she stormed off. And I believe she even left her phone behind, which is, it's kind of unusual for Avery.
What was so unusual about this, Ms. Perkins?
Well, you see, Avery's really attached to her phone. It's like a pretend or something. But, she was pretty upset. So I'm not even surprised.
Ms. Perkins, how long were you and Ms. Becker at the Fry Shack?
Not too long. We went to the mall, and that was pretty much it for the day.
Ms. Perkins, what can you tell me about the following day, March 6th of 2020?
So I remember texting Avery about a ride to school, which is, it's something we do pretty often, but for some reason she wasn't responding to my texts.
Can you hear me all right?
Yes.
Okay. Ms. Perkins, were you ever able to get into contact with Avery Becker that day?
Yeah, so Avery eventually came to pick me up. And, I asked her why she wasn't responding to her texts. And that's when we realized that she lost her phone the day before.
Ms. Perkins, did you guys ever try and look for the phone?
Yeah, we did. So we decided to ditch school that day because, we were done with finals and the classes were kind of boring. So we decided to spend the day looking for Avery's lost phone.
Ms. Perkins, where did you guys look for the phone?
So we decided to retrace our steps. So we went to the mall and then to the Fry Shack. And let me tell you, that place is like a mock trial magnet.
Ms. Perkins, what do you mean by mock trial magnet?
Well, we bumped into the mock trial team again, which we both thought was pretty weird.
Ms. Perkins, what was weird about this encounter if the place is a mock trial magnet?
Well, you see, this was usually their practice time. And also they were saying that the coach wasn't there. And, we eventually found out why Coach Brackman didn't show up that day.
Ms. Perkins, why was Mackenzie Brackman not coaching the mock trial team on March 6th of 2020?
Unfortunately, Coach Brackman was murdered while me and Avery were looking for her lost phone.
Ms. Perkins, were you or Avery Becker ever at Mackenzie Brackman's house on March 6th of 2020?
No, absolutely not. We were nowhere near Coach Brackman's house that day.
Thank you. No further questions.
Thank you. Is there any cross?
Yes, Your Honor.
You can go ahead.
Good morning, Ms. Perkins.
Good morning.
You only participated in mock trial because of Avery Becker.
It was something that we decided to do together to spend more time with each other.
And you and Avery thought Coach Brackman was a mediocre coach and a mediocre lawyer. Is that correct?
Objection, Your Honor. Compound question.
I'm sorry, Mr. Nakayama, you broke up a little bit on your objection. Could you repeat it?
Yes. Can you hear me now? I objected to compound question.
I'm just lost connection. I didn't hear the answer or anything.
Okay. Can you hear me?
Yes, I can.
All right. The objection was to compound question.
Your Honor, I will just move on to the next question.
All right. Very well.
Coach Brackman didn't like Avery. Is that correct?
I mean, he didn't like the way Avery prepared, but I wouldn't necessarily say that he despised him or didn't like him. They just didn't get along.
And from your point of view, Coach Brackman was always giving Avery a hard time about something. Is that correct?
Well, Coach Brackman was a perfectionist, and when Avery didn't show up, he wasn't happy about it. So when she didn't show up prepared, yes, he was a little mean to her.
And Coach Brackman and Avery have always had a feud.
Well, as I said, they didn't exactly see eye to eye on certain issues, but it wasn't that bad.
And the feud bothered Avery enough that she played pranks on Coach Brackman.
Well, yeah, some of his comments got to her. I mean, he could be pretty harsh sometimes.
And Avery could be rash.
At times, but not that often.
And did Avery have an inflated ego?
Rarely, but it does happen on occasions.
And after coming to another practice unprepared, Avery got demoted to the B team.
Yeah, but I mean, you know, Avery, she was so good at mock trial. She didn't see the need to prepare.
And you wanted to support Avery, so you quit mock trial so that Coach Brackman would have to move her back to the A team. Is that correct?
I mean, it was one of the reasons, but I quit mock trial for many reasons.
And after she got moved back to the A team, she got moved back to the A team after you quit, right?
Yes, but as I said, I quit mock trial for many reasons.
And after the regional tournament, Avery and Coach Brackman got into another fight.
I mean, I wasn't there to personally witness it, but that is what I've heard of.
And Coach Brackman told Avery that she didn't deserve the best attorney and best closing argument at the regional tournament.
Again, I wasn't there, but that is what Avery told me later.
And Avery got really upset with Coach Brackman. Is that correct?
I mean, yeah, who wouldn't be upset? Those are some pretty hurtful things he told her.
And so Avery wrote Worst Attorney Award with permanent marker across Coach Brackman's Porsche.
Objection, Your Honor. Lack of personal knowledge.
Any response?
Yes, Your Honor. It isn't lack of personal knowledge due to the fact that Avery could have told her about it, and also many of the other members of the mock trial team could have told her about it.
Oh, why don't you lay that foundation then?
I'm sorry, Your Honor, could you repeat what you said? My audio cut out.
You'll need to lay that foundation then, so you can proceed.
Okay. And after writing the Worst Attorney Award with permanent marker, it ruined Coach Brackman's Porsche?
Again, Your Honor. Lack of personal knowledge.
Yeah, you'll need to lay a foundation for how she knows about that.
Your Honor, I'll just move on to the next question then.
Go ahead.
Avery wanted to freak out Coach Brackman, is that correct?
I'm sorry, I didn't hear that question. Could you please repeat that?
And Avery wanted to freak out Coach Brackman?
I'm not sure about that.
And Coach Brackman kicked Avery off the team.
Yeah, I mean, it was a mistake that Avery really regrets. She tried to apologize so many times, but he just wasn't having it.
And you didn't think that was fair?
I mean, it was an honest mistake, and Avery regretted it, and she still regrets it. And she tried to apologize so many times. So, I think he could have accepted her apology.
And she even showed up to practice and was told to leave?
Yeah, I mean, as I said, Avery is so good at mock trial, and she loves doing it. So she tried everything to get back onto the team.
And on March 6th, you and Avery ditched school, is that correct?
Well, we were done with finals and the classes were kind of boring, so, we had nothing better to do.
And you claim you were looking for Avery's missing phone?
Yes, we spent the whole day looking for Avery's phone.
And in that whole day, it never occurred to you guys to use iCloud to find the missing phone?
Well, we were really focused on calling Avery's phone, using that way to find it. And we knew that we could have used another iPhone to find her iPhone, but I had an Android, and we only realized that we could have used the website later.
And you and Avery are best friends, is that correct?
Yeah, but I would never lie if someone's life was at stake.
And you would do anything to protect Avery?
But as I said, I would never lie when someone's life is at stake.
All right, no more questions, Your Honor.
Are there any further questions from the defense?
Brief, Your Honor.
All right, go ahead.
So Ms. Perkins, on the day of March 6, 2020, why did you and Avery ditch school?
Well, Avery lost her phone, and her phone was pretty important to her. So we thought, that was the best way we could spend our time looking for her lost phone.
And how did you try and find the phone?
We tried calling and texting the phone several times.
And Ms. Perkins, a topic brought up on cross-examination was your lack of use of the iCloud. Why did you not use iCloud?
Well, as I said, we were really focused on calling and texting the phone, and it just didn't occur to us at that moment.
And lastly, Ms. Perkins, how long did this entire process take?
The whole day.
Thank you. No further questions.
All right, thank you. Let me just make sure we've got everybody's names. We've got Daniel Nakayama for the defense, Sierra Speth for the prosecution, and then Anna Sherman as witness. Okay. All right, I see everybody nodding their heads. Thank you. Is the defense prepared to call the third witness?
Yes, Your Honor. The defense calls Avery Becker to the stand.
All right, let me just make sure we've got the attorney for the prosecution and the witness.
Yes.
Do we
Your
have
Honor.
the attorney for the prosecution?
Yes, Your Honor.
Okay, how about our witness?
Yes, Your Honor.
All right, you can start when you're ready.
Could you please introduce yourself to the jury?
Hi, my name is Avery Becker. I was a senior at Colorado High School.
Okay, Avery, let's just get this out of the way. Did you kill your mock trial coach, Mackenzie Brackman?
No, I would never do something like that.
Okay, let's talk about the day of the murder, March 6, 2020. Where were you that day?
I was at the mall with my friend Taylor. We were trying to find my phone.
And did you find the phone at the mall?
No, we tried looking everywhere, but we couldn't we couldn't find it.
What did you try next?
Well, we tried calling it from Taylor's phone, but it kept going straight to voicemail. So we figured it was either dead or stolen.
Could you go more in detail about the night when you lost the phone, March 5th?
Yeah. Me and Taylor, we were at the Fry Shack it was just the two of us, but there were a couple other people there from the team.
Who else was there?
Alex Cifuentes was there, along with a couple others.
And as you've heard today in court, Avery, Mr. Cifuentes claims that you texted him that night. Did you send those texts previously shown as Exhibit 14?
No, of course not. Alex is the last person I would text in this kind of situation.
And why is that?
Well, he likes to say that we have a sort of friendly rivalry, but there was nothing friendly about it.
Why did you have a rivalry?
We were always trying to competing for the top spot in the team. And now with me off, he finally has a chance to get that Best Attorney award. I always wanted.
About Alex Cifuentes.
Well, he was there the night that my phone went missing, and now he's claiming that I sent him text messages when I know that I didn't. So, yeah, you could say I'm not the biggest fan of the guy.
Okay.
Objection speculation. You are thinking that Alex took your phone.
May I respond?
Go ahead. I'm sorry I couldn't find the unmute button quickly.
Your Honor, this is based off the witness's rationally based perceptions. Ms. Becker was there when the phone went missing. She saw Alex Cifuentes there, and now Mr. Cifuentes is claiming that she sent these texts, which she did not. This is a rationally based conclusion based off of her perceptions.
Yes, but she still is assuming something about somebody that she has no proof about. So it's not, she is under speculation.
Hang on just a second. It looks like there's a dispute with the time left. So why don't we pause everything? Let's get the time situation straightened out, and then we'll proceed with the examination here. So let me have the two timekeepers unmute themselves. And can you both hear me?
Yes, Your Honor.
All right. What do you each have left for time remaining?
Well, my time is kind of weird because I'm using a timekeeping sheet, and the sheet where it automatically updates the time says you have 2 minutes and 26 seconds left when you started, but then the time I had going has 4 minutes and 27 seconds. So I'm not really sure what happened, but.
Okay, what does the other timekeeper have?
4 minutes and 52 seconds.
All right, it sounds like the 4 minute is the appropriate amount of time left. Let's go with that.
Your Honor, may we also consult about the time for cross?
Yeah, by all means, go ahead.
What did the other timekeeper have for that? Because I have 6 minutes and 9 seconds left. Okay, I have 4 minutes and 34 seconds left.
All right, that's a substantial difference. Why don't we split the difference and say that there's 5 minutes and 30 seconds left for cross?
Yes, Your Honor. Yes, Your Honor.
Okay. Do either of the attorneys right now have a problem with that?
No, Your Honor.
No, Your Honor.
All right, thank you both. Ms. Harper, I believe you were in the middle of a statement when I cut you off, so go ahead. If you need to restart, feel free.
So Ms. Becker, you are claiming that Alex somehow took your phone to send text to frame you, which I would say that's speculation, wouldn't you?
Sorry, are you, no, I just said
Your
he was
Honor,
there when my phone went missing.
I believe there is a mix-up here.
Yeah, I think, Ms. Harper, you were doing an objection, if I remember correctly, and I cut you off, and it was Mr. Wilcox's examination.
Yes, I was responding back to his question, but I'll move on, Your Honor.
Okay. Well, Mr. Wilcox, it's still your examination here, if I remember correctly.
Yes, Your Honor.
Okay, so the objection to the speculation is overruled. The original question can be answered. Let's go ahead and move on.
Okay. Avery, how did you meet Mr. Brackman?
Well, I've been on the mock trial team since I was a freshman, and he was always the coach.
And how did you feel about him?
Well, the two of us, we might not have seen eye to eye on a lot of things, but he was still a great coach. He's the reason that our team did so well.
Okay, Avery, just a couple more questions. Did you break into Mackenzie Brackman's house?
No, I would never do something like that.
And lastly, did you kill Mackenzie Brackman?
No, of course not.
Nothing further.
Ms. Harper, do you have any cross?
Yes, I do, Your
All right,
Honor.
go ahead.
Good morning, Miss Becker. So, Coach Brackman always said you were lazy.
Yes, he always said that I wasn't preparing correctly.
So, to clarify, he was saying you were lazy.
In a way, yeah.
And you and Coach Brackman didn't ever get along.
No, that's not true. We might not have seen eye to eye on a lot of things, and it might have been tense, but he was still a really good coach, and I still looked up to him a lot.
So even though you state you looked up to him, you vandalized his car.
Objection, improper character evidence. Move to strike.
Your Honor, may I respond?
Yeah, sorry, I thought I was off mute. I wasn't. Go ahead.
It's not improper characterization. I am just going off of what she has stated.
I think it's a fair question. That objection's overruled.
Could you please repeat the question?
Yes, Ms. Becker, you stated that you and Coach Brackman, you got along sometimes, and you said you looked up to him, yet you vandalized his car.
Yeah, I did. It's one of my biggest regrets, I'd say.
And Coach Brackman always criticized your work.
Yeah, I know he was just trying to help me improve, but sometimes it felt a little extreme.
And did his criticizing always kind of make you, would you say, frustrated?
A little bit, yeah. It was frustrating to have someone say that the way that you prepared and the way that you did things wasn't right. I mean, I'm always open to constructive criticism, but
when he gave you constructive criticism, you didn't take it. You kept doing your own thing.
There's a difference between constructive criticism and just criticism. Constructive criticism is there to help me improve and get better, but just straight up criticism is only there to tell someone what they're doing is wrong.
And as he was telling you what you were doing wrong and trying to help you improve, to help your overall team improve, you never took it to heart?
If someone, well, counselor.
Miss
If
Becker,
someone-
I'm just asking a yes or no question.
I didn't take it to heart because
Thank you. Next question. You told Coach Brackman, as you are a practicing attorney, that he wouldn't know a good cross if it hit him over the head.
I said a lot of things that I regret.
So
Yeah.
is this a yes? Thank you. Based on your behavior, Coach Brackman bumped you down to the B team.
Yes, he did.
And he split you up from your good friend Taylor Perkins.
I'm sorry, could you repeat that?
When he bumped you down to the B team, he split you up from your good friend, or as you guys say, your best friend, Taylor Perkins.
Well, I wouldn't say he split us up. We just weren't on the same team anymore.
So you then allowed your best friend to quit something she enjoyed doing so you could be back on the A team.
She was the one who offered. I told her that it was okay, that I would be fine, but she insisted, and I'm extremely grateful.
All right, thank you, Miss Becker. And you said that the B team was full of losers.
Well, let's just say they're not exactly, there's a reason they weren't on the A team.
And maybe it's because I might have been a couple grades lower than you, but they still were good mockers.
Of course they were.
So do you regret saying that it is a team full of losers?
Counselor, I said a lot of things that I regret. Yes.
And you received the Best Attorney Award?
Yes, I did. I was quite proud of myself.
And then Coach Brackman said you didn't deserve it because you rely on your good looks.
Objection, hearsay.
Any response?
Your Honor, I'll just move on. Actually, Your Honor, this is not hearsay because it's being introduced to prove the matter asserted.
Mr. Wilcox, any response?
I believe that is the exact definition of hearsay, Your Honor.
I think it's best just to move on. The objection sustained.
All right, Your Honor. Miss Becker, so you did write Worst Attorney Award across the hood of Brackman's white Porsche.
Yeah, I did, yes.
And then after Coach saw what you did, he basically freaked out at you.
Yeah, it was for good reason. What I did was wrong.
And you never got to apologize to him, correct?
No, I didn't. And now I never will.
And Miss Becker, my final question is that you told your mom you would get back at him if it was the last thing you ever did.
No, I didn't.
And your witness
Do
statement,
anything to make up for what I did.
in your witness statement, Ms. Becker, in lines 104 and 105, you said that.
I believe we've reached the time limit.
Thank you, Your Honor.
Are there any further questions from the defense?
Yes, Your Honor. Avery, after the incident with Mr. Brackman's car, what did you do?
Well, I went home and I cried for a while to my mom. She was the one who told me that I should go apologize and try to make up for what I did.
Did you?
I tried. I really did. The next day I went into his office to try to talk to him, but his secretary said he didn't want to see me.
What did you try after that?
Well, I tried texting him an apology and all the things that I would do to fix it, but he never answered.
What did you say that you would do to fix it?
I promised that I would personally scrub off all of the marker from the car. And I would even try to get a summer job so I could pay to get it repainted.
Did he ever respond?
No, he didn't.
Just one last question, Avery. Did you kill Mr. Brackman?
No, I didn't.
Nothing further, Your Honor.
All right, thank you. Let me just make sure we've got all of the names correct here. We have Spencer Wilcox for the defense, Eliza Harper for the prosecution, and Bella Burgess as witness.
Yes, Your Honor.
Okay. All right, I see everybody nodding their heads. Thank you. I believe that's the conclusion of the defense witnesses.
Yes, Your Honor. At this time, the defense rests.
All right. Are the attorneys prepared to move to closing arguments?
Yes, Your Honor. The defense is ready to proceed to closing arguments.
The prosecution is also ready to move to closing arguments.
Okay, you can start when you're ready.
Okay. Reckless, revenge, responsible. Your Honor, members of the jury, today we, the people of the state of Colorado, have presented our case against Avery Becker. You heard the story of Avery Becker, a reckless student who, in seeking revenge for being kicked off of the mock trial team, broke into her coach's home on March 6, 2020, and was responsible for his murder. Reckless. You heard from Kyle Cusack, who showed that Avery Becker was caught in the act of breaking into Brackman's house because she was being reckless and was too angry to think of why she might not want to commit a felony. Revenge. You heard from Alex Cifuentes, who laid out the motive for Avery Becker to murder Mackenzie Brackman. Avery was kicked off the mock trial team for vandalizing Brackman's car. To get revenge, she planned to trash his house, but in the process of that crime, was caught and killed Brackman. Because of it. Responsible. You heard from Detective Jordan Markowitz, who showed where Avery Becker was through the call detail records and who could plot the course that Avery Becker took to get from her house to Brackman's house. Let me remind you of the charges Avery Becker faces in this case. Second-degree burglary of a dwelling. On March 6, 2020, Avery Becker unlawfully, feloniously, and knowingly broke an entrance into, entered, or remained unlawfully after a lawful or unlawful entry in the dwelling of Mackenzie Brackman, located at 444 South Flower Street, with the intent to commit therein the crime of criminal mischief. Murder in the first degree. That on March 6, 2020, Avery Becker unlawfully and feloniously committed or attempted to commit second-degree burglary, and during the course in furtherance of that crime, Mackenzie Brackman was murdered. Avery Becker's intent to break into Mackenzie Brackman's house and damage his property is clear. Alex Cifuentes testified to receiving text messages from the defendant stating that Avery was going to trash Brackman's house while he was at work. The murder also happens to be at the time that Brackman normally would have been at work. The call detail records can also plot out Avery Becker's course from her house to Brackman's house. The time of the points also lines up with the time frame of the murder. This proves without a doubt that Avery committed burglary in the second degree by entering Brackman's house unlawfully and staying there unlawfully as well. And it also proves without a doubt that Avery Becker committed murder in the first degree by fatally stabbing Brackman in the left shoulder during the act in furtherance of the break-in. We, the prosecution, feel confident that when you consider the evidence and the testimony of the witnesses in this case, and that you will find in favor of the prosecution and will convict Avery Becker of murder in the first degree and the second degree burglary of a dwelling. Thank you.
You're muted.
Not again. I'm sorry. Is the defense prepared to give a closing argument?
Yes, Your Honor. Can you see me and hear me all right?
Yes, go ahead.
A rushed investigation and a rush to judgment. What happened to Coach Mackenzie Brackman was a tragedy. but it was not Avery Becker that committed this crime, because the police rushed their investigation and rushed to judgment because Avery Becker had an alibi, because there's no physical evidence linking her to the scene, and because the police failed to investigate alternative suspects. Now, in today's trial, it was the prosecution who had the burden of proof. They were the ones that had to prove to you, beyond a reasonable doubt, that Avery Becker burglarized Mackenzie Brackman's home, breaking into it with intent to either break something or to take something, and while committing that crime, caused the death of Mr. Brackman. They have failed to meet this burden because of the rushed investigation and the rush to judgment. Now, what is reasonable doubt? It is the highest burden in our criminal justice system. It is not enough to think that she possibly did it or that she probably did it. You must be convinced beyond a reasonable doubt. And ladies and gentlemen, there's plenty of reasonable doubt in today's case. First, the alibi. As you heard from both Avery Becker and Taylor Perkins, Avery was at the mall the entire day in question. And throughout the police's rushed investigation and rush to judgment, this alibi wasn't even investigated. Instead, the police want you to think that call detail records show she was exactly at Mackenzie Brackman's house. But as you heard from Professor Van Owen, these call detail records only show a range of 6 miles. That phone could have been anywhere. In this investigation, you also heard from both Professor Van Owen and the government's own witnesses, Detective Markowitz and Kyle Kuzak, that there was no physical evidence connecting Avery to this crime. There's no DNA, there's no fingerprints, there was no hair fibers or shirt fibers, no blood, nothing connecting her to the crime scene. All that they had to go on were some Ring video cameras. And all those showed were the general height and the general build of the intruder. It could have been anyone. That is reasonable doubt. You also heard about Blair Rollins, a suspect the police failed to investigate. Blair Rollins, as you heard, he was in the courtroom when his father threatened Mackenzie Brackman in open court, saying, "I'll get you, Brackman, if it's the last thing I do." And you also heard from Professor Van Owen that Blair Rollins wasn't at school that day. Blair Rollins, he had the motive, he had the means, and now he has fled the state. But the police failed to investigate him as a suspect, instead going on the first lead they got from Alex Cifuentes, person, as you heard, has major biases against Avery Becker. Now, we, the defense, we didn't have the burden of proof. We did not have to prove anything. But the prosecution's case has questions. What about the alibi? What about the lack of evidence? And what about Blair Rollins? The answer to all of these? Reasonable doubt. The prosecution wants you to think that this was a crime by a reckless teen, but the only thing reckless in this case is the reckless and rushed investigation and the reckless and rush to judgment by the police. And it is because of that that we ask you for a verdict of not guilty. Thank you.
All right, thank you. Let me just make sure we have both of your names. It was Spencer Wilcox for the defense and Connor Badger for the prosecution.
Yes, Your Honor.
All right. Well, thank you all. That is the conclusion of this round. So you can all take a deep breath, number one. Number two, I'd like to give our scoring panelists another minute or two or whatever time they need to add their scores up, and then we can all give you some brief comments. I want to wait to give you my comments until they're done tabulating their scores. So if you can both let me know when you're ready, then we'll give you some feedback.
Your Honor, I have submitted my score sheet.
All right. And Angelina, let me know when you've got yours in.
Sorry, Your Honor, I'm having trouble getting mine to I've been having trouble trying to get mine to properly download. I swear I'll get it filled out as soon as I can. I've just been writing it freehand here.
Okay. All right. If there's somebody I need to contact, let me know, and I'll send Judge Melton an email or whoever else.
Okay, I'm trying to get it. Just one moment. Okay, I have the score sheet, but I can't seem to find the submit button. I can download the score sheet.
Okay.
It's at the very bottom.
The PDF?
Yeah, it's actually a fillable form. When you open it, you fill it in, and then at the very bottom on the lower left, there's a submit button.
Okay, let me.
But I think it's got to be an open web page with the form on it that you fill in.
Yeah, because I have just this PDF. There's no button.